This is Texas Lawyer. You're listening to TL Podcasts.
This is David Judson. Last month, a unanimous Supreme Court gave the Patent Bar some guidance on an important question: whether permanent injunctions should issue routinely in patent cases. The decision in the Merck Exchange v. eBay patent infringement litigation was highly anticipated, but in the end proved something of a non-event. And in retrospect, the result should have come as a surprise to no one. Now, by way of background, Section 283 of the patent statute, of course, says that injunctions may issue in accordance with principles of equity. Now, as long as I can remember, this question has been resolved using the traditional four-factor test. Can the plaintiff show irreparable injury if the injunction is not granted? Are the legal remedies, such as monetary damages, inadequate to compensate for that injury? Do the balance of hardships favor the plaintiff? And would any public interest be disturbed by grant of the injunction? As I discussed last month, the underlying litigation involved eBay's Buy It Now feature, which at trial was found to infringe 3 Merck Exchange patents. Following trial, and while paying lip service to the four-factor test, the district court denied the patent owner's request for permanent injunction. The trial judge reasoned that a non-practicing patent owner like Merck Exchange could not show irreparable injury if a permanent injunction did not issue, especially as Merck Exchange had indicated its willingness to license its patents. In effect, one could say that the district court created a presumption or even a categorical rule that a non-practicing patent owner willing to accept license payments for use of its infringed patent should not get permanent injunctive relief. The jury's infringement verdict was more or less upheld on appeal. The Federal Circuit Court of Appeals, however, reversed on the injunction question, holding that trial courts should issue permanent injunctions against adjudicated infringers, quote, absent exceptional circumstances, close quote. In effect, then, the Federal Circuit created a general rule 180 degrees opposite that of the district court, namely that a permanent injunction should issue once infringement has been adjudicated, despite the patent owner's status as a non-practicing entity whose only business is, say, licensing the patent for royalties. Thus, in contrast to the district court, the Federal Circuit stated that the word, quote, may, close quote, in Section 283 really means shall. So the Supreme Court heard oral argument in late March and issued its ruling just a few weeks ago. Judge Thomas, writing for the unanimous court, ruled that neither the district court nor the Federal Circuit got it right. The traditional four-factor test is and remains the law, according to the Supreme Court. In particular, on the one hand, the district court erred in suggesting that irreparable injury could not be shown in cases where the patent owner does not practice the invention or otherwise shows a willingness to license the patent, or both. In its short ruling, the Supreme Court recognized that many patent owners, such as universities and self-made inventors, quote, might reasonably prefer to license their patents rather than undertake efforts to, close quote, bring their inventions to market themselves. This fact, according to the Supreme Court, should not disqualify such patent holders from satisfying the four-factor test if they otherwise can. Conversely, the Federal Circuit erred in its general conclusion that where an infringed patent is involved, a permanent injunction should be the rule and not the exception. In the end, the Supreme Court reiterated the unremarkable proposition that whether permanent injunctive relief should or should not be granted is discretionary and will depend on the circumstances of the particular case, viewed, of course, within the lens of the traditional four-factor test. Patent owners who compete in the marketplace should be able to obtain permanent injunctions against direct competitors who have been found after trial to infringe a not invalid patent claim. And that is how it should be, of course, as a patent claim is supposed to afford the owner the right to exclude others from practicing the invention. Some non-practicing patent owners also may be entitled to permanent injunctions, others will not. An interesting question is whether so-called patent trolling companies, those that obtain or buy patents merely to litigate and license, will try to reinvent themselves in some way to try to satisfy the four-factor test, as the ready availability of injunctive relief would be a hammer that such companies could wield to force large monetary settlements. I think a lot more scrutiny will be applied to the balance of hardships and the public interest factors. For example, given the Supreme Court's blessing of the four-factor test here, one can easily see how the public interest factor might have been outcome determinative in the recent BlackBerry case that was settled to much fanfare. In that case, the U.S. government had offered evidence that a large number of federal employees used the infringing service and would have been adversely affected by the injunction. In my judgment, that's exactly the kind of proof that will tip the scales for permanent relief in an injunction case. In the eBay case, however, it's hard to see much public interest in having access to the Buy It Now feature, as much as my wife and teenage children might like it. That will likely force eBay into a quick settlement. On a day-to-day basis, the Supreme Court ruling won't have that much impact. On the positive side, it may foreclose further patent reform efforts in Congress, which in part were undertaken last year to address this very question. The ruling technically does not apply to the more important question of whether patent owners should be entitled to preliminary or pretrial injunctive relief under Rule 65 of the Federal Rules of Civil Procedure, where the same four-factor test is routinely cited but rarely, if ever, met. That will be the next test case. Until then, buy it now while you still can. I'm David Judson.
This has been a TL podcast. Copyright ALM Media Incorporated 2006.